Welcome to This Explainer. Today, we are diving deep into the absolute foundation of the Philippine justice system. We're going to unpack exactly how the state defines what is and isn't illegal, where these laws actually come from, specifically focusing on the Revised Penal Code and Special Penal Laws, and the crucial limits placed on the government's power to punish. To really understand criminal law, we first have to ask a pretty big question. Who actually gets to decide what makes an act a crime? Well, the state has the authority, through its police power, to define and punish crimes. As the Supreme Court has pointed out, the right of prosecution and punishment is just a natural attribute of sovereign power. The state is basically hardwired by the common will of society to guard and defend the community. But, as we'll see, that immense power doesn't just operate in a vacuum. So here's our roadmap for today's explainer. We'll be hitting 6 main topics. 1. Defining crimes in law. 2. Limits on penal legislation. 3. Sources of criminal law. 4. The Revised Penal Code. 5. Special Penal Laws. And finally, 6. Key differences in practice. Okay, let's jump right into Section 1, Defining Crimes in Law, the rules of the game. Before we get into the sources themselves, we need to lay down some basic definitions. Think of criminal law as the ultimate master rulebook. Officially, it's defined as the specific branch of law that explicitly tells us what is forbidden, details the exact nature of those offenses, and clearly lays out exactly how those violations are going to be punished. And what about a crime itself? You know, a crime isn't just something that feels morally, ethically, or socially wrong. For an act, or even an omission, failing to do something, to be an actual crime, it literally must violate a written public law that either forbids it or commands it. Bottom line, if there's no written law against it, there is no crime. Moving right along to Section 2, Limits on Penal Legislation, checking the state's power. Now, while the state has this massive police power to define crimes, the 1987 Philippine Constitution imposes some very strict, unyielding boundaries on lawmakers to protect you, the individual. First up, this state absolutely cannot pass what's called an ex post facto law. Basically, they can't change the rules on you retroactively if it harms the accused. This is huge for your protection. It means the government cannot criminalize an act that was completely innocent when you did it. They can't suddenly jack up the punishment for a past crime, and they can't lower the standard of evidence needed to convict you after the fact. A really classic example of this safeguard in action is the case of People vs. Villaraza, which dealt with bouncing checks. The Supreme Court put its foot down and ruled that the state couldn't apply newly increased penalties from a presidential decree to a crime of estafa that happened before the decree was even a thing. Doing that would flat out violate the ban on ex post facto laws. On top of that, the legislature is banned from passing a bill of attainder. This guarantees that Congress can't just pass a law that says, hey, this specific group of people, like, say, suspected subversives, are guilty and going to prison without any judicial trial. Guilt has to be determined by a court, never by a simple act of Congress. All right, Section 3, Sources of Criminal Law, where the rules reside. Now that we know what a crime is and the constitutional limits we're working with, where do these laws actually come from in the Philippines? If you look at how this is traditionally mapped out, it brilliantly illustrates that the Philippine legal framework doesn't just pull laws out of thin air. It relies on very specific, highly codified sources. Our laws basically come from 3 places: the Revised Penal Code, special penal laws passed by Congress, and certain penal presidential decrees from the martial law era. But honestly, the most fascinating part is that little note at the bottom. The Philippines has 0 common law crimes. None. In places like the US or the UK, a judge's ruling or historical precedent can literally create a crime. Not here. Here, court decisions just explain and apply the law, they don't invent it. If an act isn't punished by the Revised Penal Code or a special penal law, it's simply not a crime, period. Let's dive deeper into that. Section 4, the Revised Penal Code, the primary code. We're going to look at the absolute biggest source of these laws. Approved way back in December 1930 and taking effect on January 1, 1932, the RPC is literally the bedrock of Philippine criminal justice. But, fun fact, they didn't just invent a whole new system from scratch. The drafting committee actually just revised the old Spanish Penal Code, which had been running things in the Philippines since 1887. Structure-wise, the RPC is elegantly split into 2 main books. Book 1 is like your universal operating manual. It covers all the big picture principles of criminal liability, justifications, and the general rules for penalties. Book 2 is the catalog. It specifically lists out the individual offenses, like murder, theft, treason, and groups them meticulously into 14 different titles. Now, under the RPC, crimes have a very specific technical name, felonies. And the defining characteristic of most felonies here is that they require dolo, which is just a fancy legal term for malicious intent or intentional deceit. Basically, if you didn't have the intent to commit the wrong, generally speaking, there's no intentional felony under the RPC. Which brings us to Section 5, Special Penal Laws, the expansive statutes. Because, let's face it, society evolves, right? What happens when the state needs to crack down on modern stuff, like cybercrime or complex financial fraud, that a committee back in 1930 couldn't possibly have imagined? So, this is exactly where special penal laws step in. A special law is a totally separate statute enacted by the legislature that is penal in character. It's designed specifically to punish acts that aren't defined in the Revised Penal Code. They run parallel to the RPC, essentially filling in the gaps as society modernizes. And finally, Section 6, Key Differences in Practice, RPC versus SPL. We've got the RPC and we've got special penal laws. These are the two massive pillars of the system, but how do they actually function differently when someone is standing trial? The absolute biggest difference? It all comes down to intent. Remember how the RPC heavily relies on dolo or malicious intent? Well, when you're looking at a crime punished by a special penal law, as a general rule, the intent to commit a crime just isn't necessary. It is entirely sufficient that you intentionally committed the prohibited act itself. Under a special law, the act alone is what makes you liable, completely regardless of your moral intent. Then there's a distinct difference in the actual punishments. The Revised Penal Code uses this highly technical, rigid system of penalties with specific Spanish names, like reclusión perpetua or prisión mayor, and these have exact durations and extra accessory penalties attached. On the flip side, early special penal laws are much more American in style. They just relied on flat, fixed timeframes, like saying the punishment is simply 1 to 5 years in prison. But over time, things kind of blended together. Lawmakers realized the RPC's penalty structure was actually pretty elegant. So later on, modern special penal laws, like the anti-fencing decree or laws on illegal possession of firearms, started to evolve. Congress began deliberately taking those traditional technical RPC penalties and writing them directly into the newer special laws. This really helped keep everything consistent across the whole justice system, even as the laws themselves were expanding to cover brand new crimes. So stepping back and looking at the big picture, these two incredibly powerful sources of law, the deeply rooted Revised Penal Code and the ever-expanding special penal laws, you can really see the massive power the state has to maintain order. But it definitely leaves us with a provocative final thought. As society keeps rapidly modernizing and passing stricter special laws that don't even require criminal intent, how will our courts perfectly balance the state's natural instinct to punish with those unyielding foundational constitutional rights that protect the accused? I mean, that delicate balancing act is the true heartbeat of the entire justice system. Thanks so much for joining me on this explainer, and keep learning.